And you picked up yet another possession or use of an abusable volatile. I don't even know what happened because today is the day set for arraignment on this case. What happened on the new case, if you don't mind?
Do you want me to read these?
Yeah, please, because I've not even heard it to know what happened.
Yeah. Okay. Also spoke to the witness yesterday, so I can tell you minutes from
Great.
that. But on October 17th of 2024, officers responded to a public welfare check at the Dollar Tree located at 14324 FM 2920. A witness stated she observed the defendant inhaling from a can of multi-purpose cleaning duster and later observed the defendant slumped over on the steering wheel of her motor vehicle in the parking lot. Upon officers' arrival, officer observed the defendant sitting in the front driver's seat of her motor vehicle with the motor vehicle running in the on position. Officer also observed several cans of multi-purpose cleaning duster beside her. Officer observed the defendant to be confused and disoriented. She admitted that she had entered the office depot to purchase several cans of duster with the intent to inhale chemicals in a manner contrary to the directions, cautions, or warnings appearing on the label. And the defendant stated she did so to create or induce a condition of intoxication, hallucination, or elation. And she was found in possession of 3 10-ounce cans and 1 3.5-ounce can.
Is there anything else that you wanted to add to this?
Me, Judge? So the witness who spotted her, she had pulled into the Dollar Tree, parked there, and the defendant's motor vehicle was right next to hers, and she had noticed that it was on. So the witness, she went into the Dollar Tree, then went down to Target, did some shopping, came back an hour later and noticed that the truck was still there and still running. So she got worried, looked through the window, and she found the defendant slumped over. She stayed watching her for a while to make sure she was okay. She didn't feel comfortable driving off. That's when the witness saw her lift her head up slowly and inhale from the can. Again, in front of the witness, and my witness, she told me, and then she slumped back down, and that's when the witness called 911 because she was worried about the defendant driving off in that condition.
I've spoken extensively with Ms. Stepanski about this, Your Honor.
You said the exact same thing to me when we came here the first time, and now she has a new case.
Yes. It's a true statement, Your Honor.
How do we get her to stop?
Well, in talking to the state, so the plea agreement that we have agreed to with the state is the maximum length of probation to 2 years of probation. So that she'll be closely monitored during that time period.
I can't monitor her 24 hours a day, though.
Yeah, but she knows that she's, subject to, random testing or urinalysis and different things.
Still not going to show. I'm forbidding you from going to any store that sells this kind of stuff. You're not to go to any Walmart. You're not going to any Home Depot.
So she's also willing to sign a no driving affidavit, Your Honor, and so only her husband would be driving her anywhere. And so I think that her husband threatened her to divorce. I just me being frank, over this. If this ever happens again, her husband's divorcing her, is what he's told her, and is going to be closely monitoring her, and she's not driving by herself.
You realize that what you're doing is you deprive your brain of oxygen when you do this, and at some point perhaps you'll hemorrhage yourself, perhaps you'll end up brain dead, you'll incapacitate yourself, that you're going to be unable to without the ability to speak. But you do this, and then you get out there, and it happens again.
It scared me so much this time, and
I believe it. I believe it. I don't believe one iota. Nope. You sold me the same thing. No.
I'm currently attending NA meetings, which I will continue to attend.
I think that, like I said, the combination of her not being able to drive to be able to go get this stuff and her husband helping to monitor that, and enforcement of the 2 years of probation and making sure that she knows that, you know, she's under
I have a sponsor.
surveillance, that I don't think it will continue to be a problem. I think that when there's been monitoring, there hasn't been a problem. This is just me kind of pulling back the curtain here because we're entering a plea.
Mr. Haddad, how do we get it to stop?
This is, man, I'm sorry, Judge, if I could just finish that thought for a second.
Look, I'm all ears
Yes, sir.
with any recommendation as how to get it to stop, because I mean, it's not something that I can test that'll show whether someone's using or not.
Judge, at this point, I mean, I was hoping that the TRS would recommend something such as like HUA, that's like a intensive treatment made for women, that's,
Yes, I mean, yeah,
I'm thinking HUA might be a good place to put it.
Figure out what the TRS is kind of.
Right.
I think that that's the best thing that we need to do. Yeah, I think that,
But my opinion, Your Honor, is that the no driving affidavit will cover or will fix the problem. This was as soon as she started to drive, basically, it became the problem. You know, when the husband said, okay, you can drive, then she went to the store and did that. But without her being able to drive, and like I said, you know, the husband making sure that that's not happening, because again, he's not tolerating any of
is
this.
the husband here?
He is not here today, but I can get him here if you'd like, Judge.
I mean, I think, Michael, I think you hit the nail on the head. I think what we need to do now, and Craig, I think what we need to do now is have our TRAS to see where we go, because we have clinicians that will be able to tell us how to tackle this problem, because I'm truly at a loss of how to get it to stop, because theoretically, this is something that you can get anywhere, right? You can have it delivered through Amazon, right? So,
Sure, but that hasn't been her MO of doing any of this. I understand you. I hear your words.
she's been able to drive.
I understand.
Right.
Well, she wasn't able to drive for a while after this happened or whatnot, and then it wasn't a problem. And then when driving resumed, then that resumed being a problem. So that's why I think
People know that for
the
sure.
no driving affidavit would fix that.
Ms. Brown?
I mean, I've explained to her that, you know, what she's signing up for, you know, is a lengthy probation. It's a 2-year probation with potential constant monitoring that whole time, plus whatever TS conditions and other kind of help that they can, you know, help her with. And then, you know, that if she messes up in probation that she signed up for, you know, 180 to, you know, that's, you know, what she's understanding. I know that when she was in jail, she spent 3 days in jail on this new offense or whatever, and I know that was a pretty devastating experience for her. She's, you know, 65 years old and, you know, takes a ton of medicines, which she didn't get and stuff when she was in jail, and I know that was a big deal. She's having panic attacks in jail and things, but I think the conditions that we've agreed to with the state are sufficient. I mean, I wouldn't have signed up for
I mean,
it.
I'd like to put on there no possession of any kind of volatile container that can be abused
That's
to get
fine.
high. I want, you know, no going to Home or Office Depot, Walmart. Ma'am, I want you to understand that if I find you with another of these containers, and I don't care what you're doing, where you're going, who you're with, I'm going to put you in a rehab facility in the jail. And I mean, if that's what we need to do to get you to stop, I'm going to do it in a heartbeat. Do you understand? I mean, you're killing yourself slowly. That's all that's happening. And the problem is that everyone around you is suffering. What happens if you do this in the middle of the road while you're driving? I mean, God, if you kill someone, you get charged with murder. Is that the last thing we want you to do is to spend the next 30 years of your life in prison because of a drastic and catastrophic event where you kill someone. And in that kind of stupor state, if you're in a car, you're begging for it to happen. Okay, so I guess I'd like to do the TRAS to see where we go. So what we're going to do is I don't know how to move forward with this, Ms. Stefanski. So what I'm going to do is I'm going to have you evaluated by our clinician to see what they suggest is the best way to go forward. So I'm going to have you meet with them, and I want you to be honest, because I want to move forward in the best way possible. If you're not honest with them, a motion to revoke can be filed. We'll put you in custody, and we'll do it next time in custody. I don't want to have to do that, so be honest in the evaluation. Be honest with yourself. I'm now taking away your privilege to drive for a year. You're not allowed to drive. You're not allowed to use be in possession of any kind of container where you can get high from it. And I don't want you to go to any Office Depot. I don't want you to go Walmart or any of these places that you can also buy these from. You understand?
Sir.
It's 180 days in jail, probated for 2 years. You will do thinking for a change, a DWI education class, 2 victim impact panels, a TPAS, with the conditions you must fulfill: substance abuse treatment, no breath test refusal, no drugs, no alcohol, guardian interlock so that we know that you're also not consuming alcohol, and a one-time donation of $100 to Matt. Is this how you understand the agreement?
Yes, sir.
I think the max is a year, right? On the first, it's a year.
For probation.
Yeah. For license suspension, I think the max is a year. If it was 2 years, if I can do 2, I'd rather do 2, because I think that I just don't want you to go anywhere near a car until this problem has been tackled. Do you understand, ma'am? Do you have any questions?
Certainly.
There are other things in life that give you that kind of rush instead of using a can. You need to find another outlet, but cans, that's not a good way to go, because you're really going to sue some irreparable damage the last thing you need is to become a vegetable. And invariably it's going to happen at one point or the other. How do you plead to the offense, Mr. Vansky? Guilty or not guilty?
Guilty.
I will find you guilty. I'll send you the agreement. Is there anything else that you wanted to add?
Nothing else, John.
Michael, anything else, guys?
No, just the other 2 cases.
Okay, so part of the agreement is this DWI, they're going to dismiss your other 2 inhalant paraphernalia cases as well, okay? All right, and wish you best of luck. We'll have you do the TRAS, and then I guess just give me a heads up when you do it, will you? And then Craig, I'm going to reach out to you so you know when we get it back. I'll let you know what it is, that way
That's not.
that you know as well. They may say inpatient, I don't know.
Right, and you understand that. They could
Understand
give
that.
you inpatient treatment.
All right, ma'am.
We don't know.
Best of
Depends
luck.
on what they feel like is appropriate.
See you soon.
Thank you for the,
So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you're not for it, one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight, as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no caller ID. The defendant spoke to the officer and admitted to calling the complainant 100 number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. Really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. Life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. You have the ability to hire a lawyer, Mr. Humphrey. Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back two metal sheets that lead to two large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again.
The complainant filed a civil lawsuit against the defendant for not paying rent and that the complainant was there to obtain properties. Or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a
I
look
mean,
at it.
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time,
Of
Really.
course, Judge.
So,
Thank you.
but until that time, don't pick up a new case. Don't go back. All right. So Vic, you want to give me a date?
Yes, Judge, how is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond condition. We'll have you sign it, and then you'll be free to go. Okay?
Thank you, Your Honor.
Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. Ms. Newton, you now stand charged with two more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An AFIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items was $268.
She has a theft from December of 22, a theft from June of this year, of last year, and now two more cases. Was she on bond for either of these cases when she picked up the two new cases?
Let me see, Your Honor.
Okay. You are looking at Miss Newton here. Was she on bond for any of these cases, or were they all just in open status? It's 254, 8009.
Your Honor, it appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the court processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got put in. So it's a third name.
On the 251, it appears she posted bond only one time on the 19th of this month. On the 243,
Yes, Judge, on the 243.
that's the one that was
the
in
GOP.
current status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good. The
So Dick's,
Dick's, and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Miss Newton, Miss Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a fifth case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? Okay. I'm going to have you sign a reset with Victoria. After that, you'll get with Felicia for your bond conditions. Do not pick up a fifth case. I'm telling you now. I don't know what you're doing, but you pick up another case. You're also not to hang out with the other person, the co-defendant in this case as well. Do you understand? So can you reach out to the MAC for her, and then she'll have conditions with Felicia? Okay, please, ma'am. Morning, Mr. Price. Sir, you're charged with two cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant Terrell and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat, but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a?
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. You see one?
I don't see one file they have what happened.
Okay, I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You will need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box while we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. Please. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. Can you look up to see if he has a...
It's not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. Let's see if I have it. Show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On January 18th, 2025, the officer observed the vehicle failing to drive in a single lane on West Grand Parkway in Harris County, Texas. The defendant was swerving in and out of 2 lanes and came close to crashing into another vehicle in the next lane. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The officer observed.
And there it is, this plot twist. Not only was she caught with an open container in the car, but she already has another DWI pending. This is the kind of moment judges live for when second chances run out. Real question. Do you think repeat DW offenders should automatically lose their driving privileges for good?
Disorientation, a moderate odor of an alcoholic beverage, and slurred speech. The defendant could not provide ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Standard filtered Brady tests were conducted, HGN 6 out of 6, walk and turn 8 out of 8, 1-leg stand 2 out of 4. The defendant was read the DIC and consented to breath. The results were .290 and .294.
So are you telling me that she had alcohol in the car while she's driving?
There was an open container on the floorboards.
Did you put any other indicators like it's cold or?
No, Your Honor.
Ms. Keys, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand, man? I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail, man. No more PR bonds. Have you run your license, Alex?
I'll run it right now, Your Honor.
Please. And any prior DWIs?
There are no priors, but there is a pending one out of Austin County, it appears.
She has a pending DWI in Austin County?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine every single time. I am now going to put an ankle monitor on you so I know that you're not consuming, and I'm also giving you a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor. Stop. I don't want you to talk about the case. I can provide you a lawyer today, but if they're telling me that you have an open DWI and now you picked up another one, I have a big problem with that. I was going to provide you a lawyer today, ma'am, if you would like, a court-appointed lawyer. Did you want a court-appointed lawyer? I will provide you a lawyer today. Ms. Keys, if you have a problem with alcohol, I'm giving you the opportunity now to address it on your own. If you do not, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand, ma'am?
Yes.
I'm going to do everything in my power to protect my public at all costs. Every single day, someone dies from a DWI in our county. I need you to fill out an application for me, or you know what? Hold on a second, maybe not. Vic, I have an application on file already. So if you just want to appoint her a lawyer, I'm going to have you sign a receipt with Victoria. You will meet with Felicia for your bond conditions, and after that, we'll have you take a seat while I'm your lawyer. I'm going to have you sign a reset. After that, you'll get with Felicia for your bond conditions. After that, I'll have you take a seat while I find your lawyer. Please.
No driving affidavit?
Oh, yeah, no driving affidavit. Right.